Assalamu alaikum, everyone.
Welcome, sir.
Uh, this occasion gives me a mixed feeling. I'm very conscious of the fact that whatever I will be saying, I will be saying before the lawmen, not the laymen. All of you are very well versed with the law already. Uh, I will try to keep this session as an interactive session so that I learn from you, and maybe you may also learn few things from me if I'm able to do that. Section 482 CRPC, it was previously in our old code. It was numbered as 561 and A. 561A in the old code gave the similar powers to the courts, to the High Court particularly, as this 482 now gives. This section 561A, as all of you may be now well versed with the fact that once A is used, A, B, C in any section, it means that there was no place for this section earlier in the code. It was inserted in terms of an amendment. This amendment of section 561 was already there. Section 562 was already there. In between, one more section was incorporated, that is section 561A in 1923. The need to incorporate this section in the CRPC was felt by the lawmakers in view of the fact that in CPC you are having such sections. For example, in CPC you are having section 151. Every lawyer who's a trial court lawyer must be very well versed with section 151. If you don't find anything in any order in any section in the CPC, you naturally take recourse to section 151. You have to implement an order, you file an application under section 151. You have to do something for which you find nothing in the code of civil procedure, you take recourse to section 151. As therefore a need was felt that why not to keep such a section in the code of criminal procedure also, where we can give powers to the courts to undo some wrongs, to secure the ends of justice. You sometimes feel that the CPC is an exhaustive code. They say that is a complete code. CRPC is an exhaustive code. Almost a remedy for everything is given in the CRPC and CPC. But the lawmakers may not have foreseen every situation. Some peculiar problems come before the courts. And if you see the statute book, you find no answers from the statute book. You see, this is a new problem. How to deal with this problem now? What to do with this problem? For example, in CPC, you have to implement a court order. If there would have been no 151, you will be scratching your heads what to do with this particular type of application, how to deal with this particular type of matter. Should we file a contempt? Should we go in appeal? Should we file a petition before the High Court? So had this 151 not been there, it would have created lots of problems. Therefore, in the CRPC also, the lawmakers thought that though the code is exhaustive, it was done in 1923, code is exhaustive, the criminal procedure code is exhaustive, but yet some situations come before the courts where there is no answer to the problems. We find that justice would be done this way. We find that justice will be done this way, but we don't know how to do this justice. There's nothing in the CRPC. So why not to incorporate a new section in the code, and that was enumerated as section 561A of CRPC. When the new code was thereafter brought into force in 1973, this section 561 got replaced by section 482. It was renumbered as section 482. So section 482 is nothing. You must remember one thing. I'll be going to different judgments thereafter, how our own High Court, or for that matter, the Honorable Supreme Court, has dealt with this section 482, how it has been defined. One thing all of us must remember, I must remember as a lawyer, that section 482 in CRPC doesn't give any new power to the courts. This is very important thing we have to understand as far as section 482 is concerned. It doesn't give any new power to the court. It only recognizes the powers which already I have. For example, all of us might have read the human rights. They say that human rights, you need not to be give the human rights. Merely because you are a human being, you are having some rights which are called as human rights. So any statute, any code, any constitution it doesn't need to specify that you are as a human being having these rights. As a human being, you are having 1, 2, 3, 4, 5, 6 rights. Since you are a human being, therefore you come with these rights. These are the rights which you inherit. You are born, you come with these rights. Section 482 it is languages like that. It says that we often call that section 482, it gives the inherent powers to the courts. It gives courts the inherent powers. Inherent power would mean it doesn't give a new power to the court, but it only recognizes the powers it already has. Why it has these powers? Because it is a court. And which court? You have to distinguish between section 151 as is in the CPC with section 482 as is in the CrPC. CrPC section 482, this power has been given only to the high courts. In CPC 151, power has been given to all of the civil courts. So important distinction between these two is 482 is exercised by the High Court. Why it was done like this? Because these lawmakers, the legislature felt it, the parliament felt it, that this is an exceptional power. This must be given to the highest court in the state, so that this power is not misused. This power is not used like the power under 151 of CPC is used by the civil courts. This 482 power must not be used by all the courts. It must be used by the highest court of the state. Therefore, you have to remember, we have to remember, all of us has to remember, High Court only can take recourse to section 482 of the CrPC. Now the question arises, under what circumstances this section 482 can be taken recourse to, and what actually we do under section 482. What actually, as a lawyers, we have to understand that if we have a problem, how to take this problem to the High Court, and how to bracket it within the four contours of this section 482. Section 482 says that if you have to prevent the abuse of the process of any court, or if you otherwise feel that ends of the justice will be secured, or you have to give effect to any order passed by under this CrPC, and then you scratch you turn the pages of the CrPC and you don't find answer to it. If there is a power of revision already there, if there is a power of appeal, if there is section 156 of the CrPC, if there is a section 190, if there is section 200, if there is section 202, if there is section 226 under which you charge, if there is section 227, then law says, I'm sorry, you cannot take recourse to 482. But once you turn the pages of the statute book from section 1 to end of the CrPC, you read all sections. There's a problem in front of you which merits consideration, which you feel it is the abuse of process of court, whatever is being done by the police authority, by the complainant, by the subordinate courts, by the magistrates. You feel it is the abuse of the process of law. It's the abuse of process of courts. Or you feel it is sheer injustice. It is miscarriage of justice. But how to deal with it? You go to section 156, there is no answer. You go to section 190 of the CPC, there is no answer. You go to section 200, there is no answer. You go to section, for that matter, 397, which deals with the criminal revisions, there is no answer. You go to the provisions of appeal, there is no answer. But the problem is real. Injustice is real. Abuse of process of court is real. Mr. A is harassing Mr. B for nothing. A check, for example, issued by any person in 2009, presented to the bank in 2010, notice issued in 2011, complaint filed in 2023, for example. And the magistrate takes cognizance against you. Now, there is some strange thing in the criminal law, that is, you cannot as a magistrate review your own orders. Complaint, check is of 2009. You present the check in 2010. Notice is issued thereafter. After notice is issued, you file a complaint against me for issuance of check in 2009. You file this complaint in 2023. Magistrate is apprised of the situation that, sir, look here, you cannot take cognizance of this case. You cannot deal with this case. The magistrate nonetheless takes cognizance against you. Now, what to do? Don't you think it is abuse of process of court? Don't you feel that this is miscarriage of justice? Statute says you cannot do it. You still do it. Now you go to the CrPC. You don't find answers how to deal with this particular situation. There's no review of the order of the magistrate. Magistrate cannot review his order. He has taken cognizance and he has taken cognizance. Matter ends there. He has to proceed further with the case. He cannot review his own order. Now you go to the High Court. You say, look here, sir, I'm coming to you as a justice of the Honorable High Court under section 482. Look how magistrate is dealing with the matter. And this is a case for which I could not have easily found an answer in the CrPC. There is nothing in the CrPC which deals with this section, which deals with this problem effectively, except this Honorable High Court under 482. So we come to this conclusion that section 482 is taken, you can take resort to section 482. It is taken recourse to only in such circumstances while the statute itself is silent about your problem, but you nonetheless find that problem is of such nature that that there is abuse of the process of court being done. For example, an FIR is registered against a person for an offense which is not an offense. You are married. Marriage, for example, this is a very trivial example I will be giving, a very kiddish and childish example, but just to make a point through. You are married. Marrying a person is not a crime, but an FIR is registered against you. Would you allow that FIR to be investigated, then charge sheet to be filed, then trial court to inquire into it, then charge to be framed, then ultimately trial to be conducted, then at the end of the day, after 5 years, 10 years, you want yourself to be acquitted? So if an FIR is there, no offense is made out. It is absolutely the miscarriage of justice. It's absolutely the abuse of process of court and as well as abuse of process of law. Therefore, you can take recourse to section 482. Therefore, we have to remember this fact always as lawyers, that section 482 is to be taken recourse to only if there is no other provision in CrPC under which we can deal with this problem. If there is an answer to this problem already on the statute book, then I'm sorry, we cannot take recourse to section 482 of the CrPC. We have to stop ourselves. We have to firstly exhaust those remedies which are already provided in the CrPC. Then again, we can go to section, then alone we can go to section 482 of the CrPC. Now, if we file a petition under section 482 of CrPC before the Honorable High Court, Honorable High Court single bench, for example, for some matter, dismisses this petition. We have to remember that there is no further appeal provided under CrPC or for any other court. You cannot appeal in the same court. There is no intra-court appeal for 482. If you go to the High Court, the learned single judge dismisses your writ petition. You can file an LPA before the division bench of the Honorable High Court. You're having that remedy always available to you. But once a 482 petition is filed before the High Court, and it is dismissed, for example, for certain reason, the recourse you can take is to the Honorable Supreme Court. You can go to the Honorable Supreme Court. In one of the cases, this matter came up before the Honorable High Court division bench of our High Court. One of our friends filed an LPA against an order of dismissal of his petition under section 482. I was fortunately appearing on the other side in that case for the respondents before the LPA bench. There's a reported judgment, Shamshada Akhtar versus Ejaz Parvez Shah by the division bench of our Honorable High Court. After discussing the threadbare law, after discussing how this LPA has come into being, after discussing how this and under what circumstances this LPA is to be taken recourse to. Our Honorable High Court said, no, if for 482 petition is dismissed by the High Court, you cannot again go to the High Court. The remedy lies to the Supreme Court. Dear friends, there I will give 2-3 examples. Firstly, of our own High Court, in which Honorable High Court has taken recourse to this section 482 and then passed orders in the matter in favor of the petitioners therein. I fortunately represented a case, I think way back in 2015, case Mushtaq Ahmad Bhatt and others versus state of J&K. This was a case in which an FIR was registered against the petitioners. I'm trying to make a point through these examples, through these cases, under what circumstances recourse to section 482 can be taken. An FIR was registered against a person under section 436A of RPC. 436A deals with if you cannot chop a fruit bearing tree. It is no longer in the IPC, but in the RPC, it was a section there. If you are chopping a fruit bearing tree, that's an offense. If the fruits are on the tree, a tree is fruit bearing tree, you cannot chop it. If it belongs to other person and then you are chopping it, it's an offense, inviting imprisonment. Perhaps it was the 7 years or something imprisonment for this. And you would not easily get bail for these offenses under section 436A. An FIR was registered against person for chopping of some walnut trees. But prior to registration of the FIR, a complaint was made by the inhabitants that look, sir, here there were some walnut trees. Mr. A came there, he chopped the trees. We are having two acts civil of civil consequence. One was the Land Revenue Act of that time. Second was the Specified Trees Act. Under the Specified Trees Act, walnut, chinar, mulberry, etc., these by the specified trees. Even if these trees are on your private land, you were not authorized to cut these trees unless and until the government didn't give you permission through a competent authority. Therefore, it was very difficult to chop the walnut trees, very difficult to chop the mulberry or chinar trees. Land Revenue Act Section 37 also made it clear that the walnut tree is a specified tree. It is a preserved tree, it's a reserved tree. You cannot cut it, even if it is on the private land. Section 38 of Land Revenue Act provided that if anybody chops this walnut tree, he is to be this punished in terms of inflicting the punishment. So I was saying section 37 of the Land Revenue Act says that you cannot cut a reserved tree, a tree which is reserved, which is preserved, which is a royal tree, walnut, chinar, mulberry, etc. You cannot cut it. 38 of the Land Revenue Act says that if you do it, if you cut this tree, then certain penalty is to be imposed upon you in the shape of fine. Now, a complaint was made against me, my client, before the Tahsildar concerned, that look here, he chopped the walnut trees. Tahsildar inquired into the matter. After inquiry, he found me guilty. He imposed penalty of few thousand rupees upon me, therefore disposed of the case. Being not satisfied with this type of punishment which was given to me by the Tahsildar, the complainants approached the concerned SHO. They filed an FIR against me, and they said that since chopping of a fruit-bearing tree is an offense under section 436A, therefore FIR needs to be registered and he needs to be dealt in terms of the relevant provisions of law. FIR was registered against me. I challenged the FIR before the Honorable High Court on the ground that the section 38 says that if punishment or penalty under section 38 of Land Revenue Act is imposed upon any person, no further penal action can be taken against the gentleman. Now, FIR, investigation, filing of the charge sheet, then ultimately, if I have been would be found guilty in this case, then I will be punished again. This will be the question of double jeopardy. When section 38 specifically says that you cannot punish a person if he has been dealt under with section 38 of Land Revenue Act, further penal consequences will not follow. FIR is not maintainable against me. Now, for a second, let us think had there been no section 482 in the CrPC. On the basis of the report of the Tehsildar that yes, I am guilty, and he imposed fine, I accepted the imposition of fine, I paid the fine. This evidence could have been used against me before the magistrate when the trial of the case would have commenced under section 436A of the CrPC. Therefore, I said that, look, sir, here, this is a case in which court has to take cognizance of the matter and quash the FIR in itself. Investigation of the case, filing of the charge sheet, inquiry into the matter, then trial of the case is unwarranted because the statute in itself says that you cannot do it. This is one example. Second example, I can give you another case. Navshad Ahmad Rathar. I can share these cases thereafter. After we finish, I can share these cases with all of you friends also. Navshad Ahmad Rathar versus State of J&K. This Navshad, he was a deputy director posted in floriculture department. He was stopped. There was some political rally going on in the Sher-e Kashmir Park. He was stopped by the beat officers, police officers there. Ultimately, he argued with them, I have to go to my office. Why are you stopping me? Nonetheless, he was stopped. Ultimately, he was a challan was issued in his name under the Motor Vehicles Act that you obstructed the traffic, you parked your car wrongly, etc., and a fine of some 3,000 rupees was imposed. This gentleman went to the social media. He said that this is the sheer abuse of process of law on part of the police authorities. I was going to my office in order to protect the political person somewhere. I was prevented from attending my office. My office was in the Sher-e Kashmir Park itself, the Emporium Garden. The Sher-e Kashmir Park, there was a political rally going on. My office was there. I was prevented. Instead of allowing me to join my duties in the office where an important meeting was about to be conducted, a challan was issued in my name for obstructing the traffic and all that. He wrote extensively on the social media. He wrote to the governor's grievance cell. The officer DYSP concerned, who was posted at that time in the at that particular place, he didn't like this episode getting the media coverage and the social media coverage. He, after 5 days, registered an FIR against this Navshad Ahmad in the Koti Bagh police station, on the ground that he tried to obstruct the traffic. Once he was asked not to do it, he raised hue and cry. He resorted to sloganeering. He resorted to making hue and cry. He came out from his car. He tried to hold this my collar. He tried to overpower me. The DSP made these allegations in the FIR, and an FIR was registered. I challenged the FIR before the Honorable High Court. Ultimately, after the exhaustive this hearing of the case, the court came to the conclusion that once you issued the challan under the Motor Vehicles Act, and you did not mention therein that he also did something more, which is an offense not only under the Motor Vehicles Act, but under the RPC also. In the challan, you say he obstructed traffic. He kept his car wrongly parked somewhere on the road. Therefore, you imposed the fine. Had he done something more in pursuance of these acts, you would have added an offense under IPC or RPC as well. Since you registered the FIR after 5 days, there's a delay in registration of the FIR, and there's a nexus, proximity, connection between these two things. The complainant, the petitioner coming to the social media, writing to the higher ups of the officer who registered the FIR against this person, going to the grievance cell of the governor as he was then. There is a connection between these two of episodes. Therefore, this FIR appears to be malified exercise of power on part of the concerned DYSP. Therefore, the FIR was cautioned. There's another example, a case, Mehreen Kausar versus State of J&K. This Mehreen was, there's an allegation of commission of a rape upon her. She registered an FIR. Later on, because of certain circumstances, the alleged rapist and the victim got married. They had a son also thereafter out of that marriage. But FIR was there. Challan was presented. This Mehreen and that gentleman who was the accused in that case came to the Honorable High Court. They challenged the proceedings on the ground that, look here, even if you prosecute this case for 100 years, the result of this prosecution will be that you will be at the end of the day destroying a family. The victim doesn't want the case to be prosecuted. The law says the offense is non-compoundable. You cannot take recourse to section 320 under which you can compound the offenses. Offense is non-compoundable. It is serious and heinous offense. But look, you please look to the situation. What will be you doing? Because at the end of the day, the purpose of every law is to secure the ends of justice. You have to see that whether the ends of justice is secured or not. You have to see whether the justice is done or not. You'll be conducting trial in the case for example, 3 years, 4 years, 10 years. After 3 years, 4 years, 10 years, what will be the end result? The end result will be that a family will be devastated, even if I am convicted. Though there are the meager chances of conviction, because the victim will be not deposing against the accused person, because they are the husband and wife now. Relying upon few Supreme Court authorities, the Honorable High Court quashed the FIR and all proceedings in that case. Now, these were few examples. You can quote many hundreds of examples as far as the our own Honorable High Court is concerned. Now, this section 482, as it was then section 561A of CrPC, it came up before deliberation, before the Privy Council, Emperor versus Khwaja Nazir Ahmad, in a case Emperor versus Khwaja Nazir Ahmad, in which it was first deliberated before the Privy Council that this is a case, this is a section which doesn't give new powers to the High Court, but it only recognizes, it only preserves the powers which it already has. This view of the Honorable Supreme Court, it was accepted by the Honorable of the Privy Council, was accepted by the Honorable Supreme Court in a case thereafter, State of UP versus Muhammad Nazim, after India got independence from the British Empire, and after the Supreme Court came into place, this Privy Council decision was given acceptance by this Honorable Supreme Court. And therefore, after this case, Muhammad Nazim Ahmad's case, the Supreme Court has passed hundreds of judgments, rather thousands of judgments on this 482. In certain cases, the powers have been widened. Yet in certain cases, the powers of the High Court to interfere in the matters have been very narrowed down. It has been curtailed. For example, a very classical case of the Honorable Supreme Court, which we often quote in the Honorable High Court, is R.P. Kapoor versus State of Punjab. In R.P. Kapoor, the Honorable Supreme Court said that if the problem is already, solution to a problem is already in the CrPC, you cannot take recourse to the 482 section. One. Second, power under section 482 has to be exercised in exceptional circumstances. Then few exceptions were laid down by the Honorable Supreme Court in this R.P. Kapoor case. It said if there is an absolute legal bar for institution of a complaint or a case or its continuation, if there is absolute legal bar for instituting a criminal case or for continuation of a criminal case, then section 482 can be taken recourse to. For example, I just gave the example of this Mushtaq Ahmad Bhatt's case, in which this Land Revenue Act section 38 was in conflict with section 436A. 38 said you cannot take any further penal action against a person. Yet an FIR was registered against me. R.P. Kapoor says that yes, if there's a legal bar, so in this case, Mushtaq Ahmad Bhatt's case, there was a legal bar under section 38 of the Land Revenue Act, that if once you impose a penalty, you impose a fine upon a person, you cannot further prosecute him under any penal law. Therefore, the R.P. Kapoor judgment has laid down few exceptions. It says this power is not an absolute power. It is not a power which you have to use. Sorry. This is not a power which you have to always use. It's not a rule. It's an exception. This power to quash an FIR, or the power to quash a proceeding, or a power to quash a complaint, or anything, or any order passed by the trial courts, is not a power which you have to use in every case. You have to use it in rarest of rare cases. You have to use it in exceptional circumstances. You have to use it by picking and choosing the cases, not in all cases. Therefore, the test is that if there is a legal bar for any case, if there is a legal for institution of a complaint, institution of an FIR, or continuation of a criminal case, then you can take recourse to Section 482. High Court would be well within its powers to quash the proceedings. Second, if on the face of it, the allegations do not constitute an offense, FIR is registered against me, but you laugh at the contents of the FIR. You say, sir, please tell me, you are registered in FIR, but let us read the FIR on the face of it, prima facie, without going deep into it, deep into the allegations of it. Let us see, even if I accept, I make an admission, I make a confession before the police authorities or before the magistrate that all of these allegations are correct. Nonetheless, these allegations do not absolutely constitute an offense. On the face of it, this is not an offense. For example, I gave the trivial example of you marry as a government employee. Yes, bigamous marriage, you cannot take recourse to. But as a government employee, you marry out of your religion, for example. As a government employee, you marry out of your religion. You are a Muslim by faith, you marry a Christian. You are a Hindu by faith, you marry a Muslim. Now, law says intercaste, interreligious marriage is not an offense. But somebody being not happy with this marriage because of ego issues, because of religious intolerance, because of any other problem in the mindset, this marriage is not accepted by any gentleman. He goes to the police, registers an FIR against you. That look here, he's a Muslim by faith. He has married a Hindu or a Christian. He's a Hindu by faith. He has married a Muslim, and he is governed by, for example, he's a government employee also, for example. Therefore, register an FIR against him for hurting the religious sentiments of people, for doing this, for doing that, etc., etc. He levels every type of allegation against you. Now, an FIR is registered. On the face of it, the allegations in the FIR do not constitute an offense. Now, why would you wait for this FIR to be investigated, you to be arrested, then you to be questioned, then a charge sheet to be filed before the court of law, then an inquiry would be done by the magistrate into these allegations, then ultimately you will be charged, then thereafter you will be tried for these offenses. You'll be tried for the offenses. Then ultimately, court after 5 years, 10 years of the exhaustive trial will say the offense is not made out. This is not an offense of marrying someone which doesn't belong to your own religion. This is not absolutely an offense. So why would you allow yourself to be put to trouble, put to hardships, to be harassed by the legal process? Therefore, you take recourse. RP Singh judgment says, RP Kapoor judgment says, you go to the Honorable High Court under Section 482. You tell to the High Court, please, sir, look here. This is an FIR. Even if we look at the face of this FIR, no offense is made out. Therefore, why would you allow me to submit to the police? Why would you allow me to go to the police, to be in the custody, to face the custodial interrogation, and then to face the trial, the lengthy trial as we are having in our country? The criminal justice system is not that powerful that the trial will be concluded within a limited period of time. It takes years together to complete a trial in the case. Therefore, you will request the High Court that look here, there is no offense is being made out. Why to keep this FIR? Quash this FIR as it is. The third thing in this RP Kapoor judgment, the third exception which the Honorable High Court, which the Honorable Supreme Court laid down is that the allegations do constitute an offense, but there is absolutely no evidence in support of that allegation. Absolutely nothing. Not even a statement from anyone. If this is a case, you can again go to the High Court. That, sir, look here, this is a case in which there can be no conviction at the end of the day. When you know there is a case, this is a case of absolutely no evidence. Therefore, you know the consequence of this case. You know that what will be the result of this case. You know the fate of this case. Ultimately, this case has to go. And if you know this case has to go, why you are putting me to the trial? Therefore, quash this FIR. Similar things were held by the Honorable Supreme Court in State of Haryana versus Bhajanlal. Bhajanlal judgment is a very famous judgment on this section 482 of CrPC. It also laid certain parameters. For example, it said that you can quash an FIR if there is no chance of conviction. You know, at this point of time, when the FIR is registered or when the charge sheet is filed, you know that this case is a open and shut case. A person accused in this person can never be convicted because of varied types of reasons, because there is absolutely no offense made out, because there is no evidence at all, or because of any other lacuna. If you bring this fact to the Honorable High Court, and you are in a position to convince the Honorable High Court that this is a case in which there is no chance of conviction at the end of the day, then why not to quash this FIR or this complaint? Second, it said then when the claims are so ridiculous or obviously unlikely, if in the FIR or if in a criminal complaint or if in the charge sheet, the allegations are so ridiculous or obviously unlikely, then also you can go to the Honorable High Court and ask the Honorable High Court that, look here, sir, this is a case, see the ridiculous allegations made against me. The offenses, the allegations are obviously unlikely. It can never be done. For example, I am being accused of hampering the smooth landing of Chandrayaan 3 on the moon, for example. Let's take this example. I am accused by someone that you prevented, you hampered, you tried to create roadblocks in smooth landing of India's prestigious mission of this exploring the moon through Chandrayaan 3. You played a role in it. You tried to obstruct it. You tried to obstruct its landing. I can go to the High Court. See, the claims are these are ridiculous allegations against me. The allegations are ridiculous. The allegations are obviously unlikely. How, as an ordinary man, I can do it? Therefore, why would you allow the FIR to be registered and then the investigation to be carried against me? Therefore, in the Bhajanlal's case, Honorable Supreme Court said, if this is the case, then recourse to Section 482 of the CrPC can be taken. Thereafter, there are other cases. For example, in Parbat Bhai Ahir versus State of Gujarat, it said that if there is a settlement between the parties and the offenses are not compoundable, they are non-compoundable offenses. The parties settle their disputes somehow. They do not want themselves to be entangled in the litigation. You could have taken recourse to Section 320 of the CrPC had the offenses been compoundable. But since one of or two or all of the offenses are non-compoundable, but you have settled somehow the disputes, you don't want the cases to be prosecuted, you can go to the Honorable High Court under Section 482 and you can request the Honorable High Court that, see here, this was actually a dispute arising out of misunderstanding. We have settled the dispute, but the only problem with us is the trial court cannot compound this case because the offenses are non-compoundable. Therefore, recourse to Section 320 of the CrPC cannot be taken. Therefore, you please quash these proceedings. You quash this charge sheet. You quash this FIR, whatever it is. Second, it said that even if the offense is non-compoundable, you can do it, but you have to take care of this fact that you cannot put a general principle that always you can go to the High Court, that you say, look here, sir, we have settled our disputes, therefore compound these offenses, therefore quash this FIR. High Court will go into case depending upon the facts and circumstances of each case. Therefore, every case in which there is settlement, it is not essential, it is not requisite, it is not permissible, or maybe it is not likely that the High Court would intervene into the matter and quash the allegations against you, quash the FIR. The facts and circumstances of each case will be taken into account. For example, the nature of the offense, the gravity of the offense, the heinousness of the offense. A person has been murdered, a person has been raped, dacoity has been done. There is a social impact of these offenses also. There's an impact upon the public at large also. Therefore, in the facts, peculiar facts and circumstances of the case, the Honorable High Court can say that, look here, you have made out a case before this Honorable Court, but sorry, we cannot, though you may have settled, but it's not in the interest of the public. It's not in the interest of the public policy to quash this FIR. Therefore, it's not that every non-compoundable offense which you cannot compound before the trial court, you can bring to the High Court. High Court will apply its own test in view of the facts and circumstances of each case, and the High Court will thereafter see that, look here, I cannot quash this FIR, I can quash this FIR because of its heinousness, because of its the gravity of this offense, or because of other things in this offense. Likewise, thereafter, there was another very recent judgment of the Honorable Supreme Court, NS Niharika Infrastructure versus State of Maharashtra. It primarily dealt with that quashing is okay, but you need to see whether you can, in the interim stage, stay the investigation in a case or not, or you can provide, don't take coercive steps. For example, an FIR is registered against me. Can I go to the High Court and say, sir, please quash this FIR? Till you quash this FIR, you stay the investigation in it. You stay the powers of the police. You curtail the powers of the police. You provide that no coercive measure should be taken against me. The Honorable Supreme Court laid down certain parameters. For example, it said that the power to investigate, the power of the police to investigate, is a statutory power. You cannot curtail it always. You cannot do it on the mere asking of a petitioner. The power to investigate in terms of 154, 55, thereafter 156 of the CrPC is a statutory power of the police. You cannot stay this investigation on the asking of the petitioner. Petitioner comes to you and says that till you quash the FIR, please stay the investigation. The Honorable Supreme Court said, no, you have to be very cautious. Don't stay investigations in each and every case. The court thereafter said that courts should not thwart the investigation into cognizable offenses. It rather, this Niharika judgment, it narrowed down the scope of 482. Earlier, almost every petition was entertained by the High Court, and the interim orders and the final orders were passed. But when this Niharika judgment came, infrastructure judgment came, the Honorable Supreme Court curtailed the powers of the High Court. It said you cannot curtail the powers of the police to investigate a case. You cannot thwart the investigation into the cognizable offenses. If the offense is cognizable, you cannot ask the police not to investigate it. You cannot ask the police, do not take coercive measures against a person. Then it said only when no cognizable offense is made out. For example, an offense is non-cognizable, for which the prior permission, the sanction of the magistrate is important. You have to, firstly, you cannot investigate this offense of your own because it's a non-cognizable offense. Yet you try to investigate it. Offense is non-cognizable. Police tries to investigate it, notwithstanding the fact it is non-cognizable. Supreme Court says in this is a case in which you can take recourse to your powers under 482, and you can stay the investigation of the case. Then the court again said that ordinarily the court should not interfere into the police functioning. Then it again said that the FIR, in a case, you cannot stay an FIR on the ground that it's not exhaustive. It is not the encyclopedia of the facts. All facts have not been given in the FIR. It said then FIR needs not to be an encyclopedia of facts. And FIR, 2 lines, 3 lines, if an offense is made out, a grievance is made out, you have to register an FIR, and you cannot challenge this FIR before the Honorable High Court under section 482 on the ground that there are no details in the FIR, that the FIR is not exhaustive, that the complaint is not exhaustive, that it is not, because it's not an encyclopedia, because the law doesn't want an FIR to be an encyclopedia of facts. Therefore, you cannot stay this FIR merely on the ground that certain facts are not mentioned in this FIR. And then ultimately, Honorable Supreme Court said that instead of staying the FIRs as an interim measure under section 482 of CrPC, before you can finally quash this FIR or whatever you want to do with it, instead of doing it, instead of staying it, you should revert back this petitioner to the trial court and request the court to grant you anticipatory bail. Instead of staying the FIR, so the powers, I'm trying to say how the powers of the Honorable High Court have been, which were exercised earlier under 482, very, as a matter of rule by the Honorable High Courts. In this Niharika infrastructure judgment, the powers have been very narrowed down. The powers have been curtailed. It has been said you cannot issue a blanket order of stay. Instead, you try to ask that petitioner to go to the trial court, to go to the concerned session court and apply for anticipatory bail instead of staying the investigation, because power of police to investigate a matter is a statutory power which you cannot curtail under any other statutory section. Maybe under section 482 you cannot do it, because power of the police to investigate a case is a statutory. You may feel that it is prevent to abuse process of courts. You may feel that the ends of the justice may be secured like this, but you will be interfering into the powers of the police. Powers of the police are defined in the CrPC under a separate chapter. Your powers as a high court under 482 have been defined under a separate chapter. You should not interfere with each other's power. Police cannot interfere into the decision making power of the court. Likewise, the court cannot interfere into the investigation right of the police to carry on investigation in the case. So in nutshell, 482 you can take recourse to if there is abuse of the process of court, if there is ends of justice can be secured, there is sheer injustice being done because of any action, panel action, legal action, court order proceeding. You can go to the Honorable High Court and you can ask to the court that, look here, this is a problem. There is nothing in the statute book, there's nothing in the CrPC which comes to my rescue. Therefore, I am coming to the Honorable High Court, the highest court of the state, under its inherent powers to do this particular act for me. Because if you don't interfere into the matter, there will be miscarriage of justice. There will be the abuse of the process of courts. And the law settled legal position is now that invoking of power under section 482 is not a rule, it is an exception. You have to do it in exceptional circumstances. Only when the laws laid down under this RP Kapoor, or for example the Bhajan law, or for example the Niharika infrastructure case, are met out, those are followed, only then you can take recourse to this section 482. This was my small effort to just throw some light on this section 482 as it has been described on the statute book, and it has been thereafter explained by the Honorable High Court. If there is any question or query, I'll be very happy to answer it.